Welcome to the debate. Today we are diving into one of the most consequential legal conflicts in American governance, the struggle over how we protect the fundamental right to vote. We're looking specifically at the constitutional tension surrounding the Voting Rights Act of 1965, the VRA, a tension that really pits two great constitutional purposes against one another.
That's right. And at the heart of this conflict are the Reconstruction Amendments. So on one side, you've got the 15th Amendment, ratified 1870, which, expressly forbids denying the right to vote based on race or color, and gives Congress this broad power to enforce that. But then on the other side, we have the shadow, really, of the 14th Amendment's Equal Protection Clause, which the courts have increasingly used to demand a sort of judicial color blindness.
Exactly. So our central question today is this. When Congress uses the VRA to combat modern forms of discrimination, what we often call second-generation barriers, things like gerrymandering or vote dilution, should that enforcement be governed by the 15th Amendment's original race-conscious and, remedial mission? Or must it be confined by the stringent, formal standards that have developed under the 14th Amendment? I'm going to argue that the 15th Amendment really demands deference to Congress and a functional, results-oriented approach to achieve true political equality.
Well, I understand that perspective, but I just don't think the 15th Amendment operates in some kind of constitutional vacuum. While Congress certainly holds enforcement power, that power is subject to strict judicial interpretation. The courts have insisted quite clearly that any congressional action, even when it's under the 15th Amendment, must adhere to key judicial standards, particularly the need to prove discriminatory intent for a constitutional violation, and also the requirement that any race-based remedies have to survive the demanding test of strict scrutiny.
My argument really starts with history. The 15th Amendment was enacted to address a specific, persistent national problem: the exclusion of Black citizens from the political process. The VRA was the congressional realization of that goal, plain and simple. Now, for the VRA to actually work today, its protections have to extend beyond those crude, first-generation barriers like poll taxes or literacy tests, which were fundamentally about ballot access. It has to cover the more subtle tactics used now. We're talking about vote dilution. This is the sophisticated tactic of, say, packing minority voters into one district to minimize their influence elsewhere, or maybe cracking them across multiple districts so they never form a majority anywhere. Restoring the 15th Amendment to its primary role, I think, requires accepting that it is inherently race-conscious. It was designed to remedy centuries of racial exclusion. And because the 15th Amendment is so specifically targeted at voting discrimination based on race, I believe it should be subject to a more permissive or deferential standard of review than the 14th Amendment, precisely to prevent the 15th Amendment from being, essentially swallowed or erased by the broader Equal Protection Clause.
That's certainly a compelling argument based on historical purpose. But have you considered the implications for the separation of powers here? The scope of congressional enforcement power isn't self-defining, right? It's limited by the judiciary's interpretation of the underlying right. And this boundary was, I'd argue, clearly established by the Supreme Court in Mobile v. Bolden back in 1980. That case held that a constitutional violation of the 15th Amendment requires proof of discriminatory intent. It's simply not enough to show that a practice merely had a discriminatory effect. Now, when Congress responded 2 years later in 1982 by amending VRA Section 2 to include an effects test, allowing plaintiffs to win if they showed a practice results in unequal opportunity, even without proving intent, they intentionally created a legal gap, a schism, if you will. This legislative choice for a broad statutory remedy now constantly, bumps up against the narrower constitutional standard defined by the courts. And furthermore, any race-conscious measures intended to enforce the 15th Amendment must still pass strict scrutiny under the 14th Amendment's Equal Protection Clause if race is shown to be the predominant factor. This strict standard views all racial classifications with, presumptuous skepticism, demanding they be narrowly tailored to achieve a compelling state interest, even if the intent behind them is remedial. Core debate. Okay, so I want to start with the standard of review for congressional action. You argue for deference because the 15th Amendment is narrowly focused, right? But the courts seem to be moving toward consistency across all the Reconstruction amendments. The demanding congruence and proportionality test, which was developed in the 14th Amendment context, that City of Bernie v. Flores, it asks, does the legislative fix Congress created closely match the size and scope of the constitutional problem the courts have actually identified? So, if the Supreme Court were to apply that demanding Bernie standard to VRA Section 2, Congress would essentially have to show that its effects-based remedy is proportional to the proven constitutional violation, which, as we've established, requires discriminatory intent under Mobile. If Congress can't show that proportionality, Section 2 is really at risk of being declared an overreach, undermining the very VRA mechanism that protects against modern dilution. The courts simply cannot grant too much deference, or Congress effectively gets to redefine the Constitution itself.
I see why you'd think that, but I find the move to take a high bar designed for sweeping legislation under the broad 14th Amendment, citizenship, due process, equal protection, huge areas, and then apply it to the highly targeted 15th Amendment. Well, I think that's a remarkable and frankly problematic doctrinal development. The 15th Amendment deals with one thing: race discrimination in voting. That's it. Historically, the court, in cases like South Carolina v. Katzenbach, gave Congress massive deference to fix the voting crisis back in the 60s. We should honor that historical understanding, I believe. Applying the Bernet standard, which, let's be honest, is complex legal shorthand for questioning whether the remedy fits the intent-based constitutional injury, applying that to the 15th Amendment simply prevents Congress from fixing the real problem of evolving, subtle discrimination. Granting Congress deference in this one, narrow, historically necessary area is just not the same as letting them rewrite the entire Constitution. And this leads us directly to the consequence of that intent standard you mentioned, the functional futility, really, of the 15th Amendment when it faces modern discrimination. The original architects of the VRA, they recognized discrimination would evolve. They explicitly wanted to eliminate sophisticated as well as simple-minded modes of discrimination. But when the Supreme Court mandated that plaintiffs must find a smoking gun, must essentially prove what was in the hearts and minds of the legislators drawing the lines, it made the 15th Amendment functionally useless against complex second-generation barriers like gerrymandering. That's precisely why Congress had to step in 1982 and create the effects test for Section 2. It was a legislative necessity born out of the court's ruling to restore a functional mechanism for challenging discrimination that was hidden behind seemingly neutral procedures.
Okay, I acknowledge the political reality, the necessity, perhaps, of the 1982 amendment. It definitely fixed the law to make it easier to bring lawsuits. But we have to be precise about the nature of the schism you mentioned. When Congress passed that amendment, they were actually quite careful to state in the legislative history that they were not overturning the constitutional rule established in Mobile. They weren't changing the constitutional interpretation. They were creating a broader statutory remedy. The constitutional standard remains proof of discriminatory intent. And this distinction, it matters deeply when states or localities try to comply with the VRA. When advocates push for, say, majority-minority districts or specific electoral structures based purely on an opportunity or effect standard, they risk demanding that outcomes be manufactured or maximized based on race. Section 2 itself explicitly states it does not mandate preferential treatment, yet this line can become incredibly blurry when the focus shifts entirely away from malicious intent towards achieving specific electoral results based purely on racial demographics. And that blurry line, well, it immediately triggers the constraints of the 14th Amendment. When states draw electoral districts using race as a predominant factor, even if it's to comply with the VRA, courts must intervene. This is the requirement of strict scrutiny established in the Shaw and Miller line of cases. And that standard views race-based districting as inherently suspect. It asserts that the courts must prevent the VRA from being used to demand racial stereotyping or, the separation of voters into racial buckets. The 14th Amendment demands colorblindness in government action, and that principle applies even when the 15th Amendment is the supposed source of the remediation.
But applying the 14th Amendment's colorblind, very individual-focused principles to vote dilution just seems fundamentally inappropriate.
because vote dilution isn't really an individual harm, it's a group-based aggregate harm. Think of it like this. Vote dilution isn't like excluding one person from a building. It's more like slicing up a large cake, the electorate, so that the minority group gets all the crumbs scattered thinly among many slices, meaning their collective vote doesn't translate into actual political power. In the context of persistent racial bloc voting, which is a reality, race often acts as a source of political community. Shared experiences translate into shared political interests. This colorblind 14th Amendment framework operates directly against the 15th Amendment's race-conscious protections because it penalizes the remedial action itself. It creates this inherent tension where the VRA statute, designed specifically to combat racial inequality in voting, is scrutinized using a principle that completely ignores the political realities that made the remedy necessary in the first place. And if we look way back to the origins of the 15th Amendment, we can see its potential to address structural barriers, not just simple access denial. Consider the pre-VRA case, Gamillion versus Lightfoot, 1960. The city of Tuskegee literally redrew its boundaries into this absurd 28-sided figure just to carve out virtually every single black voter. Now, that's not subtle, that was blatant. The Supreme Court struck that down under the 15th Amendment, focusing specifically on the inescapable human effect of that racial gerrymander. That shows, I think, that the 15th Amendment was always intended as a path marker covering structural dilution claims, not just turning people away at the polls.
I agree that Gamillion is foundational, yes, but many influential jurists, including Justice Thomas, for example, narrowly construe that case. They argue it only covers the most extreme access claim where a racial group is basically excluded entirely from the constituency and does not extend to mechanisms that merely affect the weight or the efficacy of a ballot. By maintaining this very narrow reading, the judiciary severely limits the constitutional role of the 15th Amendment in addressing complex modern vote dilution issues. And this means that virtually all practical remedies against dilution are forced to rely solely on the statute, on VRA Section 2, which, as we've discussed, remains constitutionally, shall we say, tenuous, because its effects test goes beyond the court's established intent standard for the Constitution itself.
And more about efficacy, about the vote actually mattering. If the 15th Amendment is going to fulfill its purpose in the modern era, we have to embrace a functional interpretation that recognizes these second-generation barriers and, crucially, grants appropriate deference to Congress to devise solutions. Its original design wasn't to segregate, but to integrate previously excluded populations into the democratic process. The 15th Amendment, I believe, remains the essential constitutional foundation for achieving political equality, and its remedial purpose must be respected, not sidelined.
And I would conclude by grounding this debate back in, well, constitutional boundaries. The reality is that the courts define the constitutional standard, and currently, that standard requires proof of discriminatory intent for a violation. Full stop. Furthermore, any effort to remedy racial inequality in districting using race-conscious methods will face the high bar of strict scrutiny derived from the 14th Amendment. The complexity we face today stems from the fact that Congress created a broad and arguably wise statutory remedy in Section 2.1 that works in practice while the underlying constitutional protection of the 15th Amendment remains judicially defined and, frankly, much narrower.
Indeed. And what we see here, ultimately, is a persistent and powerful tension. A tension between the legislative desire to achieve substantive political equality in practice and judicial frameworks that prioritize a more formal, colorblind methodology. Understanding this divergence, this gap, is absolutely crucial to understanding the fragility of the Voting Rights Act today and really the future of minority representation in America.